Hi, everybody. Welcome. Welcome. Hey, Ian.
Hi, Jordy.
Good to see you. We've got Sue here. So looking forward to hearing from Sue. Hey, Sue.
Hey, how are you?
Good, good.
Hi,
Welcome.
Sue.
Nice to see you guys.
Great to see you. Thanks for joining us.
People are joining as we speak, but just a little background. We welcome Sue Stamm to East Dade Academy's weekly webinar. And Sue's been with us before. And she is counsel at the Office of the Children's Lawyer, a wonderful lawyer, a wonderful person to work with, a wonderful person. I know her personally, and we're thrilled to have her. And today we're going to focus on some litigation and guardianship issues, as well as open the floor to questions. And you can feel free to send them through the chat to me directly. That might be the best way. And then I can sort of go through them and raise them with Sue. Ian, good to see you. I missed you last week. I'm sorry I wasn't here.
Yeah, no problem. Great to see you too. But I echo what your comments about Sue. There's nobody at their office that is any more available, in my view, than Sue. In terms of just if you have a question or concern, she's always there to help us with our really unique scenarios that the Children's Lawyer's Office touches on our files. So I appreciate all the years of free phone calls you've been giving us. So thank you.
So I'm going to turn it over to you, Sue, to talk about certainly the role of the children's lawyer where there are minors or unborn involved in litigation. We'll have a little bit of a discussion, I'm sure, here and there. So over to you.
Well, thank you for inviting me again. It's always a pleasure. As I said last time, I really love the informal format of this. I think it's terrific and super to be included. So what I'm going to do is I'm going to divide my talk into two parts. And obviously, if there are any questions, send them through the chat, and I will make sure that I leave some time. I have a tendency to go on, and but Jordy and Ian will just keep me in check. So we're going to start talking about litigation guardians, and then I'm going to talk a bit about guardianship of property. So one of the things that comes up a lot is that my office, all we deal with is minor children. We also deal with the unborn. So we, I think, have a sensitivity to the involvement of minors and the unborn in litigation, whereas often times in cases, people just forget that they exist or forget that they have rights. And then we get served, after, for example, just recently we got served on a matter where a trust had been found to be invalid without serving us. So we thought that was kind of a bad thing. So one of the things is just to develop sort of a sense of when you need to serve us and when children require responsibility. Ultimately, minor children cannot litigate on their own. They have to have a litigation guardian. And a minor child is anybody under the age of 18, even that incredibly annoying 17-and-a-half-year-old who knows everything. They still need a litigation guardian. But that 18-year-old who knows everything is perfectly free to go and litigate on his or herself. The other thing about anyone under 18 is any contract that they sign isn't binding. So we regularly get files where minors have signed off on something or other, approved accounts or given their inheritance to their parents or whatever the case may be. Minor children cannot sign contracts and they cannot litigate in court unless they have somebody acting as their litigation guardian. On the contract side, we'll talk a bit about guardian of property later. So historically, there's a lot of history that leads us to where we are now with specific offices in Ontario that deal with these rights. But this is not something that has just come up recently. The courts have grappled with minor litigants for a very, very long time because their interests are in play in litigation. And there's three main reasons we have litigation guardians. So the first one is to protect incapable people from unscrupulous adults. Okay, so this child is needs to be protected. Sometimes you need to deal with the property interests of a child. And the third one is to legally bind the child. So those are the three reasons why you need a litigation guardian. So point number one is that you do not need a court order to start a proceeding on behalf of a person under disability. So any adult who is able to swear the affidavit provided for in Rule 7.02 can be litigation guardian for a minor child. It's very easy to sign the affidavit and get started, but it's not so easy to stay with the litigation as the costs escalate. So it's a good idea to review and discuss the items in the affidavit carefully. The first item in the affidavit that you need to discuss is that a litigation guardian who is acting in a representative capacity has to have a lawyer. So you cannot self-represent and be a litigation guardian. And what this usually means is that the litigation guardian must not just have a lawyer, but must pay for the lawyer. And that is all the way through. So this is, of course, unless you have some kind of deferred billing arrangement or the lawyer's acting pro bono. But that is what the litigation guardian must be committed to do. The adult litigation guardian absolutely cannot have an adverse interest to the child. So the relationship is a fiduciary relationship. The child's interests are paramount. So if the adult has related interest in the litigation, it may be that there is a conflict and they cannot act as litigation guardian. And the other item is that the litigation guardian may end up liable for the costs of the other party in the litigation. Right. All right. So here's the next point. The next point is that the children's lawyer does not have to start every application on behalf of minor children whenever an individual asks her to act. So when it comes to starting litigation, the children's lawyer is litigation guardian of last resort. So we're often people will call us up and say, you know, my mom died, she has a will, and my children are not beneficiaries in the will, but under a prior will, they are. Children's lawyer, you start a will challenge. Or my child was not left anything in this estate or not left enough. Children's lawyer, please start a dependent support claim. Or the interpretation of the will that the other parties are saying is unfavorable to my child. Children's lawyer, please start an application to interpret the will or rectify the will. And to that, we say that as a party applicant, the children's lawyer is litigation guardian of last resort. That doesn't mean she won't bring the claim. And you can ask us to bring a claim. But we don't just bring claims. So there are two circumstances that we tend to act more frequently. So the first one is when we're dealing already with the estate, and we're dealing with an estate trustee who is unresponsive. So we are served on probate applications and we follow estate administration. So say, for example, a child has a $50,000 legacy under the will, and the estate trustee is directed to hold that in trust until age 21. And we will say, estate trustees, show us that you have set up this $50,000 legacy in an in-trust for account for the child, and the estate trustee doesn't respond. So we may, in a case like that, of our own accord, bring an application to compel a passing of accounts or remove an unresponsive trustee, even if that person is the child's own parent. The other place that we tend to act more frequently are bringing cases, support claims on behalf of children who were left either an insufficient amount or completely left out of a will. Those cases, we always ask, is there someone else who can bring the litigation? We're not a legal aid office, so we can't act on every single one of these cases where there's financial hardship in the parent to act. So we typically look at, is there a major legal impediment? We tend to act, for example, if the family is undergoing some kind of very, very stressful circumstance. For example, there's an intrafamilial murder that led to this death, and that any litigation amongst the family members would be a very bad idea. Or the child is in the care of the Children's Aid Society, or the child is in another country, and the parent likely would have difficulty being appointed litigation guardian because they would be unable to post security for costs acting outside of the country.
Sue, just a quick question on this situation. So we see this kind of regularly where there is a potential claim where a minor might be involved. Who should we be thinking about as an alternate litigation guardian? Who like, how do you see this, and where do you see?
You know, every family is different, right? So obviously the best litigation guardian is usually the child's custodial parent, as long as they're not in a conflict. If they are, sometimes another person in the family will act. Sometimes a professional can be the litigation guardian, a lawyer or an accountant can be a litigation guardian for a child and can bring that proceeding. So quite frankly, anybody who is prepared to swear this affidavit can start that litigation. But as I said, I think it's important to, to understand most litigation takes, around 2 years to get anywhere, and they have to have a stick-with-itness. We are often served into cases where someone starts litigation on behalf of a child, and then they have a falling out with their lawyer, and we are served with a defendant's motion to appoint the children's lawyer. And, the other thing I will say in these cases is, some people start litigation. For example, let's just say a child was left $1 million in an estate, but the other $1 million went to the deceased second wife. So the child's mother was really furious about this and felt that she needed to bring a dependency claim on behalf of the child to get the other half of the estate because, for example, this child needs to go to Harvard and private school and have this very, very high-end life or something like that. That is not the kind of case we're likely to take on. We look at the provision in the Succession Law Reform Act as you need to provide adequately for your dependents. You don't have to provide perfectly or extravagantly for them. I think that there is certainly in litigation these days this kind of desire that if we don't like the will and we're a bit disappointed with it, we can just make a dependent support claim. And you can. It's just that we're not going to be keen to take it over. So we will try and resist being appointed. And if we do get appointed, we're probably not going to be as, if we don't see the litigation as having great merit, we're not just going to proceed out of the same kind of anger and vitriol as the prior litigation guardian. We're going to look at the legal issues and we will likely resolve that case. In that case, for example, we might just discontinue it. So we don't have to start these cases, but that's not to say we don't. We certainly start a lot of litigation on behalf of minor children. And if somebody feels that there's no one else who can start a piece of litigation, absolutely write to us and set out all the facts and everything and we will consider it and decide whether to act. Now, one of the things we're sometimes asked to act on cases where people just don't have any information at all. And we're not an investigatory body, right? Like you can't say, my mother died in North Bay. I haven't seen her in 40 years, but I believe there's a will that leaves something to my child. Where did your mother live in North Bay? Oh, I don't know. When did she die? I don't have a date of death. She changed her name 6 times. I don't know any of that. We will not take on a case like that. It may be that there is merit to it, but we're not an investigatory body. So you have to come to us with some level. You don't have to know everything, of course, but you have to come to us with some level of basic facts. Okay, so when are we required to act as litigation guardian? If a child is a named respondent or defendant in a state litigation, the children's lawyer is the default litigation guardian. So what that means is that the children's lawyer is the litigation guardian. For a child that's been hauled into litigation by someone else, we act. And that is an access to justice program to make sure that no child defendant in an estate matter doesn't have a proper litigation guardian. So if, for example, that happens and you're like, oh, I don't want the government acting for my child. If you want, you can bring a motion to have the children's lawyer step aside in favor of another litigation guardian. And if that litigation guardian is non-conflicted, has counsel, and is prepared to swear the requisite affidavit, my office will step aside. So we're not going to step aside on behalf of, for example, a non-custodial parent who looks to be after the child's money. We're not going to step aside in favor of a stranger to the child whose interests in the child's welfare seem unclear, but a parent who seems to be acting in the child's best interest, we would likely step aside for. So we're not there to prevent parents retaining lawyers and defending their children's interest in estate litigation. We are there just as a default. Most people are pretty happy to have us because litigation's quite expensive, and it's a whole lot cheaper to have us involved than to retain counsel, even though at the end of the day, we may well seek legal expenses. They tend to be a fraction of the legal expenses sought by private counsel. All right, here we go. Children over 18 do not need litigation guardians, even if they're totally irresponsible. So sometimes in litigation, children turn 18 during the course of litigation. These are horrible situations because we've been acting for the child all the way along. And on that date, no more. The relationship is over. Now, the file could be, in the middle of discoveries. It could be, we're not likely to allow anything active to happen around the child's 18th birthday. But if you are a litigation guardian for a child, say you've brought a proceeding and the child is going to age out at a certain point and turn 18, it's a good idea to be live to that. So we have a tickler system that reminds us who's turning 18. And if we start litigation or become involved in litigation for a 16-year-old, we will try and create some sense of what will happen when the child ages out of this litigation. What is our plan? So we may, for example, retain outside counsel and talk to them about coming up with a private retainer for the child once the child no longer needs a litigation guardian. Okay. Next question, do minor beneficiaries have to be named as parties and the children's lawyer served? So a claim against the estate need not involve any beneficiaries, and they often don't need to be served. So for example, if you're bringing a claim against an estate for a debt of the deceased, you can just bring that against the estate trustee in his capacity or her capacity as a trustee of the estate. And the estate trustee can defend the claims without the beneficiaries as parties. In fact, most wills specifically provide an estate trustee with this power, but it is generally speaking a power of trustees. And as such, the estate trustee can actually legally settle the application without court approval. And it's procedurally a lot less cumbersome than involving all the beneficiaries and the minors, right? So for example, a spouse brings an equalization claim under the Family Law Act, as I said, creditors' claims, claims for quantum meruit, claims for constructive trust. Support claims, however, under Part 5 of the Succession Law Reform Act are different, and all beneficiaries have, or anybody who might be affected by the support claim, has to be on notice. You don't have to be named as a party, but you have to be served. You have to be on notice. And if a minor is a beneficiary of the estate, the children's lawyer, we must be served. That said, an estate trustee who's planning to settle a claim against the estate is wise to advise the beneficiaries of the pending settlement, and certainly our Office of the Pending Settlement. So let's say, for example, a spouse has an equalization claim against the estate. You would say, look, I've got this equalization claim. She's seeking this. We think that we could settle it here. This is a reasonable amount. And what you will ask us for is what we call a comfort letter, which is to say, if I were to settle this case at this number, children's lawyer, would you object on a subsequent passing of accounts? And while we will provide these letters, it's also a good idea to get adult beneficiaries who you think may object later on and say that the settlement is improvident, right? Especially if there's some hostility between the claimants and the beneficiaries. So it's not a bad idea, even though we don't need to be consulted and aren't a party, to just make sure your beneficiaries are on side with the settlement. And if a beneficiary is a minor, it's a good idea to just say to the children's lawyer, look, I'm planning on settling this claim in this way. This is why I think it's reasonable. And you can get from us a comfort letter. And then if you pass your accounts, you know that one issue is not going to be an issue we would object to. Okay, settlement involving minor children. Just looking at the time. Settlement is a rigmarole of a process involving minor children. It's not the same as adults who can settle a case, sign minutes of settlement, and off you go. In a settlement involving a minor, you need to justify to a judge that the settlement is in the best interest of a child, right? It does two things. One is it makes sure that the child's interest in the estate is dealt with in a safe and responsible manner. And number two, it just prevents people making improvident settlements on behalf of children. So, for example, if you say you're making a settlement for $100,000 and you say, and we're going to have the $100,000 paid to mom who has a gambling problem, and she's going to invest the money for the child. That is the kind of thing that a judge probably won't approve. So if the funds are going to be managed by someone in some way, that would have to be explained to the court. The other item would be, what are the legal fees, right? How high are they? If these are being approved in the settlement, the court would need to know all the details. So anyone who's dealt with our office will know that we will file a detailed affidavit in support of the settlement, and all litigation guardians are required to do it. And if a court feels that they haven't got enough information, they can seek a children's lawyer's report from us if it's someone else, or they can just not approve the settlement. All right, I'm not going to go into this in too much detail because I see that we are ticking along a bit.
Sue, we might just finish up with the litigation and maybe deal with guardianship of property separately. But taking, for example, whenever my view is, or my red flag goes up if I see a trust in a will and this will is being litigated, or there's something involved here. Because very often they're not even named minors, but there are a gift over on the death of the life tenant, for example, or the end of the trust to issue then alive. And we have these unborn beneficiaries.
Right. Okay. I was going to talk about that very next.
Fabulous.
There we go. So I do remember when a certain unnamed judge got onto the estates list, and I was in chambers with him, and I said, "But we act for the unborn," and he started laughing, right? So it's a funny thing, acting for the unborn. So there's a rule that provides for unborn representation, and that's Rule 10. And Rule 10 provides for unborn or unascertained beneficiaries of the estate. And why do these people need representation if they don't exist? Well, number one, they may exist, and they may, when they exist, have actual rights. And number two, you want them to be bound by whatever result is achieved. So they can't sometimes later on open up the proceeding to say, we were not represented. So Rule 10 is interesting. Unlike Rule 7, it doesn't require the children's lawyer to act, but it's just difficult for the unborn to retain a lawyer. I mean, let's face it. And the parents or grandparents of unborn just don't usually feel like paying for someone to act for the unborn. They could, right? There's nothing stopping a private person deciding, I'm going to act for the unborn. It's just that they tend not to. So typically, the children's lawyer acts on behalf of the unborn. We are served in probate applications on behalf of them. And Jordy's right. Anytime you see a trust that is and that has any kind of long time window, this is a moment when your skin should prick up and say, okay, let's play out this trust. When is it going to distribute, right? Or when is the last possible moment it could distribute? And look at who it's distributing to. So a lot of these trusts are fully discretionary family trusts with lots and lots of discretion built in. But there is a big class of people who don't exist yet who may still have an interest in this trust. And that would be the unborn. So if a trust is created for the issue of Bob, and the trust is going to continue until 21 years after the last life in existence, which is sort of the perpetuities period, that or sometimes it's just 21 years after the trust is set up, because there'll be a deemed disposition. Either way, so super long-term perpetuities or kind of long-term 21 years, those are times where you need to think, we probably need to serve the children's lawyer on behalf of the unborn. If you are serving us in one of these, and there are some minors and some unborn, do us a favor and just tell us, give us a family tree, show us who's living, who's not living. That way we get a sense of where the interest lies. We can't guess, we don't know families. And so it's important for us to log actual minors versus unborn beneficiaries, and also to consider whether there is a conflict between different classes of beneficiaries, because that does happen sometimes in long-term trusts. So Rule 10 also deals with the unascertained. And, when I started working at the children's law, we used to just say unborn and unascertained, and it drove me around the bend. I'm like, no, what's the difference, right? And I'm like, what is unascertained? So what I understand of unborn are, this is the family tree, and these are the people who could be born, right? Unascertained is we just don't know who the hell these people might be. One might be a power of appointment in a will. For example, I leave a big trust to my wife, and she may in her will appoint. And even if she has already appointed, she may change her mind. So there's an unascertained class there. It also sometimes falls into situations of intestacy, where a person dies with no known next of kin, and you have to go out searching the wild world for their next of kin, second, third cousins in the home country where they're from. And that would be an unascertained interest, and we would be served on behalf of that unascertained interest. Again, we're not an investigatory office. We're not going to go and find them, But while the estate trustee has hired their heirship searcher and is doing their searching, but still needs someone to keep an eye on the estate while they're looking for the unascertained, our office will act in that intermediate period before heirs are determined. And if at some point you find the heirs and they're all grown-ups, then our office will just drop off and let the grown-ups deal with the estate. But we will have been following the estate administration on behalf of the unascertained in an intestacy situation where it appears the person dies without known next of kin.
So Sue, just because we're wrapping up now, we have one question that I wanted to raise about litigation guardians and the and minors hitting 18. What about a minor who's incapable or will be incapable mentally, for example, at age 18? What happens in that situation, and how does that work out?
So typically the public guardian and trustee acts for adult incapable people. And so what tends to happen is that when a children's lawyer when we're appointed litigation guardian for someone who is likely to be incapable, so let's say we're dealing with a child that has a catastrophic injury or is nonverbal or it's not clear. Yes, they're on the spectrum. They may be, they may not be. What we might do is we might build in to, and we often have people who we're really not sure if they're capable or not. I mean, we've all dealt with them in litigation. They seem maybe capable. So what you do is you build into your appointment as litigation guardian a requirement that the person be assessed for their competence. And this is the interesting thing. Capacity assessors are really good at assessing the ability to draw up a will or, but you try and find a capacity assessor who assesses for the capacity to conduct litigation.
Right.
It's few and far between. So I have to say, I only know one person who does it. I'm not going to give her name out because she's probably inundated, but if you need someone, let me know. And, and booking her is really hard. So lots of lead time, lots of organization. And then they go into with the person in great detail to try and understand whether this person, I mean, it's quite clear that someone who is nonverbal and, is being fed through a feeding tube is likely incapable. The assessment is probably, a doctor's note would be enough to have the public guardian and trustee appointed as their litigation guardian. But there are tons and tons of people in this gray zone of capability. And I mean, we often deal with them in litigation where they're clearly have some mental incapacity and often drive litigation really far. And it is a question whether the person is capable. I think it's a question for all litigation lawyers to consider their client's capability to conduct litigation, especially if they keep getting instructions to do things, like challenge elections over and over and over again when you don't succeed, etc.
Right. Well, thanks. Sue, we like to end right at like after about half an hour, so I'm gonna have to say thank you so much. We're gonna have to have you back to talk about guardianships of property. Because but as we see, children's lawyers office involved so often in litigation, especially in estates work, and Sue,